Good evening, everyone. Welcome to the Chinese American Scholar Forum webinar series, co-sponsored and co-organized by over a dozen nonprofit Chinese American professional associations. My name is Chongji Zhang, assistant professor at the University of Virginia and a volunteer of the Chinese American Scholar Forum. Also, on behalf of two co-hosting organizations for tonight's events, Peking University Alumni Association of Washington, D.C., and Peking University Alumni Association of New England, I would like to welcome each and every one of you to join this webinar, either from YouTube or from Zoom. Before we start, I would like to make some logistics announcements. There will be a Q&A session at the end of the seminar, where we have collected the questions submitted by the attendees in the Zoom registration. The moderator will integrate the questions and ask the speakers during the Q&A session. Meanwhile, attendees on the Zoom webinar are welcome to submit questions in the Q&A box on Zoom by clicking the Q&A button at the bottom of your Zoom screen. And the moderator will select questions from the audience and the panel to ask the speaker. Unfortunately, we are not able to monitor the YouTube live streaming website simultaneously, so any questions posted on YouTube will not be honored. Please keep in mind that this is a public forum and use caution when submitting questions. Please do not include confidential or private information in your question. The video of this webinar and previous webinars will remain available online at YouTube and accessible through our website, casforum.org. In light of concerns in the Chinese American community over the increasing hate crimes against Asian Americans and increasing accusations and criminal investigations brought by US law enforcement agencies against academic scholars of Chinese descent in recent years, the Chinese American Scholar Forum webinar series aims to provide a platform where fellow scholars, experienced lawyers, and other professionals are invited to discuss and reflect on the challenges facing academic scholars in the US, and to provide insights into the process, common legal allegations, as well as recommended best practices in pursuing your academic endeavors. This is the fourth webinar of the Chinese American Scholar Forum's webinar series. Tonight, we are very delighted to have two distinguished guests, Dr. Xiaoxing Xi as the speaker and Dr. Rory Truex as the moderator for tonight's webinar and discussion. Also with us tonight is a panel of forum organizers and representatives of the co-sponsoring organizations and other distinguished guests. Before we officially start, let me introduce our moderator, Dr. Rory Truex. Dr. Truex is Assistant Professor of Politics and International Affairs at Princeton University. His research focuses on Chinese politics and authoritarian systems. His work has been published in top political science journals and features in the media, including the Wall Street Journal and the New York Times. He is the founder of the Princeton in Asia Summer of Service program, which annually sends Princeton undergraduate students to rural China to run an English immersion program for local students. Welcome and thank you to both of you, Xiaoxing and Rory. And now the floor is yours, Rory.
Thank you, Chongzhi, for that introduction, and thank you all for inviting me to be part of this conversation. It's really an honor, and just by a short way of introduction, so I'm a humble political scientist, and I've kind of become involved in the thinking about the China initiative through some work I was doing for a think tank out of Johns Hopkins. And the assignment at the time was fairly open-ended, which is think about the espionage issue and the China initiative and how and whether this should proceed moving forward. And for me personally, coming in without much knowledge of what was going on, very quickly it became clear that a lot of what was happening out of the DOJ, especially under the Trump administration, but continuing still, is deeply problematic. And so I think this is an important moment we're in for US-China relations, but more specifically for this community, the Chinese American scientist community. I think it is important to have these kinds of conversations. And it's a moment where coordination and information sharing and leaning on each other and learning from each other is important. So I'm really honored to be a part. So you're not here to hear me talk, you're here to hear Professor Xi talk, who of course needs no introduction, but I will introduce him nonetheless. Xiaoxing Xi is the recipient of the American Physical Society's, sorry, my notes here, I lost them, 2020 Andrew Sakharov Prize. He's Laura H. Carnell Professor of Physics at Temple University. Prior to 2009, he was a professor of physics and material science and engineering at Penn State. He received his PhD degree in physics from Beida and the Institute of Physics, Chinese Academy of Sciences in 1987. His research focuses on materials physics of oxide boride and two-dimensional dichocogenide thin films. He is the author of over 350 refereed journal articles and has 3 US patents. He's a fellow of the American Physical Society. And most importantly for our purposes, since 2015, after he was wrongly accused by the Department of Justice, he has spoken out actively for open fundamental research and has been an advocate against racial profiling in the scientific community. So with that introduction, please join me in welcoming Professor Xi. Professor Xi will speak, I think, for roughly 40 minutes, and after that, we'll be able to open it up to Q&A. Thank you.
Thank you, Rory, for the introduction. Now, let me start my slides. Yeah, and I would like to thank the Chinese American Scholar Forum for giving me the opportunity to talk here today about the challenges facing academics in the US who are suspected as non-traditional collectors for China. My goal today is to use my own experience and other actual criminal cases to give you an idea on what kind of risks you have, either because you are ethnically Chinese or because you have academic collaborations or entrepreneurial activities in China, and what you can do about it. The challenges we face are shown plainly by this interview of the FBI director who spoke about the China Initiative established by the Department of Justice in 2018.
Just as we're sitting here having this conversation, the FBI has over 2,000 active investigations that trace back to the government of China. They are pursuing a campaign of intellectual property theft, economic espionage, cyber intrusions that target businesses big and small all across the country and our academic research institutions. And they do it not just through traditional government officials, which they certainly do, but also through what we sometimes call non-traditional collectors, which can be businessmen, high-level scientists, high-level academics, people like that, all of whom are in different ways incentivized to steal American innovation and confidential information and take it back to China.
Clearly, the US-China tension has led the FBI to consider Chinese scientists and academics non-traditional collectors or spies for China. Calling Chinese scientists and academic spies for China is blatant racial profiling, and it is false. Recently, I have given talks to rebuke this and other falsehoods propagated by some politicians and law enforcement officials. You can watch my talks at Harvard and Stanford on YouTube at the addresses given here. In these talks, I highlighted the Jason report on fundamental research security, commissioned and endorsed by the National Science Foundation. Jason is an independent group of preeminent scientists that conducts mostly classified studies on science and technology matters for the US government. The Jason report said that Chinese scholars, either Chinese citizens or US citizens originally from China, are typically not acting as representatives of Chinese Communist Party or the Chinese government, and are not necessarily in agreement with the aims, methods, or policies of these institutions. Chinese scientists are a diverse group. There are many who are strongly for China, just as there are many who are strongly against China. I know people who strongly oppose the Chinese Communist Party, but actively collaborate with scientists in China. The Jason report said that Chinese scholars must be treated as fellow residents or citizens of our country and should be judged on their personal actions and not by profiling based on the actions of the government and the political institutions of China. No matter what America's China policy is, whether the two countries are in Cold War or hot war, it is wrong for the law enforcement to profile Chinese students, scientists, and professors based on where they come from. However, I'm sure the FBI does not ask whether you are for China or against China when it started those 2000 criminal investigations. Just like during World War II, I'm sure the government did not ask whether a Japanese was a Democrat or Republican before sending them to an internment camp. I want to add that the situation is not going to change anytime soon. The relationship between the United States and China has entered a new era of high tension. This is reflected in policy declarations of both the Trump administration and the Biden administration, which agree on a tougher stance on China. This position has broad support from the American public. According to a recent Pew Research Center survey, 70% of Americans support getting tough with China on human rights issues and 53% on economic issues. Also, 55% support limiting Chinese students still studying in the US. Notably, this is towards Chinese students, not China as a country. We need to understand that the hostile atmosphere towards China, and by extension, ethnic Chinese, will be here to stay for a long time to come. Being suspected as spies for China inevitably leads to being charged as spies for China. As a victim of the government's crackdown of Chinese scientists, I can tell you what it is like. On May 21st, 2015, I was woken up by loud pounding on my door. I ran to open the door and saw many people outside my house. Some were armed and some had battering ram ready to take down my door. An FBI agent showed me his badge, asked for my name, and announced my arrest. Another agent turned me around and put the handcuffs on me. In the meantime, the armed agents in bulletproof vests burst into my house, running about and shouting, FBI, FBI. They point their guns at my wife and two daughters and order them to walk out of their bedrooms with their hands raised. When the FBI agents took me out of my house in front of my family, I had no idea when I would see them again. At the FBI's Philadelphia field office, I was subjected to DNA sampling, mug shots, and fingerprinting. At the end of a 2-hour interrogation, the FBI agent finally told me that I was charged for having made a device called Pocket Heater for a Chinese collaborator. I said immediately, that's absurd, because I had never shared the Pocket Heater information with anyone in China. I spent the next several hours in the US Marshal Service jail, where a US Marshal ordered me to strip naked and bend over against the wall so he could inspect whether I hid anything in my body. In the early afternoon, I was marched along with several prisoners into a courtroom for my initial appearance and was released on bail of $100,000 or my house with various travel restrictions. My wife and the elder daughter picked me up outside the jail late in the afternoon. Just as we pulled into our driveway, we saw the FBI agent waiting for us with a search warrant. For about 2 hours, FBI agents searched every corner of our house and carted away our belongings. The sensitive technology I was charged with stealing was a device called Pocket Heater. The indictment against me said that a US company, STI, invented the Pocket Heater that revolutionized the field of superconducting magnesium diboride thin film growth, and I stole it for Chinese government entities in an effort to help them become world leaders in the field of superconductivity. The charges were totally false. I had never shared STI Pocket Heater information with anyone in China. In addition, this Pocket Heater was not sensitive at all, and there's nothing revolutionary about it. It was a widely known device originally invented by a German professor. It was not classified, not a trade secret, and not export controlled, and it has little commercial value. There were 4 wire fraud counts against me based on 4 emails I sent to Chinese colleagues from my Temple University email address. Count 1 confirms that certain technology has been delivered to a laboratory in China. But a certain technology was an equipment built by my collaborators based on published results from my lab, and it had nothing to do with the Pocket Heater. Counts 2 to 4 were not even about magnesium diboride, but completely different materials. They were about oxide and had no use for the STI pocket heater for magnesium diborate. Being innocent does not automatically mean that I will be exonerated. I was fortunate to have found a team of great lawyers for my defense. It consisted of a lead counsel from Washington, D.C., who was the leader of the team, a local counsel from Philadelphia who was familiar with the local court, and an IP attorney who can communicate effectively between scientists and the lawyers. My lawyer contacted top experts in my research field, as well as a co-inventor of the pocket heater, and gave them all my email communications with Chinese colleagues. After examining these emails, they all concluded in their affidavits that I did not share the pocket heater technology with China. Armed with these affidavits, my lawyers gave a 48 slides presentation to the government on the science of the case. At the end, my lawyers made a request to the government: find your own expert, give them all my communications with Chinese colleagues, and ask, is there any evidence that Professor Xi shared any pictures, drawings, or schematics of the STI MGB2 pocket heater? We also shared with the government a draft motion to dismiss the indictment, which we were ready to file with the court. It said the government's entire prosecution is based on the presentation of false and misleading testimony to the grand jury, premised on the faulty understanding of basic and non-controversial scientific principles and the concepts by an FBI agent who was not qualified to be the government's sole witness before the grand jury. On September 11, 2015, the government dismissed the case, citing additional information came to the attention of the government. Although the charges were dropped, the false prosecution wrecked my life and that of my family. One day, I was a respected researcher and department chair. Overnight, I was painted as a Chinese spy all over the news and the internet, and faced the possibility of up to 80 years in prison and a $1 million fine. I could not appear on campus, could not talk to my students, and I was no longer the principal investigator of my research grants. We were isolated and worried about my career, reputation, our livelihood, the mounting legal fees, and even my personal safety. In those months, we went through a roller coaster of emotions: outrage, defiance, disbelief, sadness, frustrations, and despair. The extreme stress has left deep scars that will be with us for the rest of our life. On the other hand, the ordeal gave me a unique experience most scientists do not have, and taught me valuable lessons that very few Chinese scientists appreciated. I have been eager to tell everyone about these lessons. Lesson number one: when you see a DOJ news release charging someone for stealing secrets for China, it is not necessarily true. When the government charges someone with crimes, it is natural for people to think that the charges were the fact and that he or she must have done something wrong. However, it's important to remember that one, the person charged is presumed innocent until proven guilty, and two, what the government says is not necessarily true. In my case, what the government said was totally false. Lesson number two: innocent Chinese American scientists are being unfairly targeted. Researching while Chinese carries tremendous risks, and you don't have to do anything wrong to be charged as a Chinese spy. The China Initiative put a target on the back of anyone with Chinese ethnicity. Lesson number three: the DOJ is criminalizing academic collaborations with China. It was clear to me during my interrogation by the FBI agents that they knew nothing about how science is done, and they saw routine academic activities as criminal. According to a key official on the DOJ's China Initiative, academic collaborations with China is by definition conveying sensitive information to the Chinese. Anyone who has academic collaboration with Chinese colleagues can become a target of the FBI. Once you are a target, your email will be read, your phone will be tapped, and everything you have ever done in your life will be under the microscope. And the China Initiative makes sure that the FBI has enough resources to do it. My case is just one of many cases that involve Chinese professors or those who have interactions with scientists in China. Every case is different and unique. In the following, I will show you 10 more actual criminal cases besides mine, so you can get a more comprehensive understanding of the risks we face. I will present them in the chronological order based on the dates when the professors were arrested. The information is purely based on my personal reading of court documents and the public records, and I do my best to be accurate. I will not comment on the merits of the cases, which you will have to judge yourselves. On the right is a list of steps that will take place in a criminal case. I will comment on them when they come up as I talk about the cases. The first case, Yudong Zhu, associate professor of radiology at New York University. A complaint was filed against him and the two co-defendants on May 19, 2013, followed by an indictment against him and the one co-defendant on October 2. The government has several ways to charge people. It can use either a complaint, an indictment, or an information. The indictment is the formal charging documents. To get indictment, the prosecutor must present evidence of a crime to a grand jury, who then decide whether to bring criminal charges. A complaint is simply a sworn statement of facts presented by an agent to a judge about probable cause for charging somebody. Based on the complaint, the judge can then issue an arrest warrant. A complaint must be followed by an indictment. Information is also a formal charging document, but it only requires the prosecutor to present sufficient evidence to a judge. It is often used when the defendant pleads guilty to different charges from those in the indictment. Zhu was charged for failing to disclose his work with a Chinese company on MRI on NYU's conflict of interest form, and did not disclose that he had a patent on MRI before joining NYU, and received royalty payments from the Chinese company on the patent. He was also charged with bribery because he hosted researchers from China to work on the NIH projects, who were paid by the Chinese company. The next step after charging is arraignment, when you will be formally charged and you will enter a plea, either guilty or not guilty. After the arraignment, the period of discovery starts. During the discovery, the prosecutors must give the defendant materials and evidence they plan to use at trial. Remember that all your computers, hard drives, and many documents have been taken away by the FBI during the search of your home and office, which can happen before, during, or after the arrest. Your university most likely has stopped your access to your email account. So you don't have access to materials you need to prepare for your defense. Discovery is the time when the government must provide them to you, for example, in the form of an electronic copy. Whether they gave it to you sooner or later is totally up to them. So waiting for the discovery materials could be frustrating. During the discovery, the defense and the government will also file various motions. In Zhu's case, Zhu filed a motion to suppress evidence obtained from his computer. From the motion, we learned that NYU started the investigation and contacted the FBI later. NYU also gave the FBI permission to search Zhu's computer, which Zhu said it did not have the authorities to do. After the motion, the government responded, then Zhu responded to the response, then the judge ruled, denying Zhu's motion. The government also filed a motion to suppress Zhu's subpoena to NYU's medical center for documents related to his case. The judge partially denied the government's motion. In March 2015, Zhu decided to plead guilty to one misdemeanor charge in a superseding information. Pleading guilty is equivalent to being convicted by a trial, except that you lose your right of appealing the verdict. He did not have to go to prison and paid $5,000 fine. At that time, it was quite shocking to see that errors on the university's conflict of interest form could be a misdemeanor crime. Nowadays, it's always a felony. The second case, Yujie Ding, professor of electrical and computer engineering at Lehigh University. Ding and his wife had a company built on SBIR funding, which is common for academics to commercialize the result of their research and encouraged by universities. SBIR is a federal program to support small companies for R&D. Another similar federal program is STTR. Both SBIR and STTR have 3 phases. Phase 1, to prove merit and feasibility with a small funding. And if successful, phase 2, to continue phase 1 work with much bigger funding. Phase 3 is for the small business to pursue commercialization themselves without further government funding. Ding was charged with wire fraud related to the SBIR grants their company obtained from NASA. He was charged for defrauding the government because his wife was the PI on both the phase 1 and the phase 2 projects. But the work was actually done by people in Ding's group at Lehigh University. He was arrested on November 3rd, 2014, and released on November 4th. So he spent the night in jail. The indictment against Ding and his wife had 10 counts, 4 based on 4 emails sending invoices for payment to NASA during phase 1, and 6 based on 6 emails of invoices during phase 2. The case went to a jury trial in November 2015 for 15 days, and the jury found him not guilty for the phase 1 related charges, but guilty for the phase 2 related charges. Ding was sentenced to 1 year and 1 day in prison. From the news report at the time, we learned that Ding's lawyer used a racial profiling defense, saying Ding was singled out for scrutiny because of his Chinese name. The NASA agent who investigated the case denied it, but admitted the case started when he was checking whether Ding violated export control laws. After he found that Ding's work was not covered by the export control laws, he found something else. So it was about being a Chinese after all. The next one is my case. I've already told you about it earlier, and here I list all the steps. After our presentation to the government on August 21st, 2015, there was a scheduling hearing on August 27th, when we told the judge we were ready to file a motion to dismiss the indictment. We then gave a draft of the motion to the government, telling them we would file it if they didn't drop the case. It would then be public for the whole world to see. On August 30th, the judge ordered us to file the motion before September 11th. On September 11th, the government dropped the case. The fourth case, Yiheng Zhang, professor of biological system engineering at Virginia Tech. He owned a company that worked on SBIR, STTR grants. In September 2017, Zhang was charged for submitting SBIR and STTR proposals for work already completed in China. In an email to employees of his company, Zhang said that if funded, the money will be used to support other projects. Proposing to do one research, but intending to use something to do something else with the funding is defrauding the government. Zhang was arrested on September 20th, 2017, and released on December 26th. So he spent 3 months in jail. A year later, the case went to bench trial, which means there is no jury just in front of the judge. One can request a bench trial if they think it offers a better chance to prevail. Zhang's trial took 4 days. During the trial, Zhang filed a motion to ask the judge for an acquittal. Then after the trial, he filed a brief for the same. In them, they said Zhang and the former CEO of the company had a falling out, who then repeatedly contacted NSF and the FBI, accusing Zhang of violating laws. Also, the work done in China was not the same as the proposed work. 5 months later, on February 21st, 2019, the judge found Zhang guilty of several counts. 6 months later, the judge sentenced Zhang to time served. No more prison time on top of the 3 months he was in jail after the arrest. The judge explained his life is effectively ruined. Zhang's lawyer said Zhang never sought personal enrichment. He just wanted to do more research. Zhang wrote a letter to the judge saying he had given up his ambition and pride, and his new life purpose was to do everything for God. The next case is Xiaoxing Xi, professor of electrical and computer engineering at Michigan State University. Xi had an employment dispute with MSU over his positions at universities in Hong Kong. He also had a dispute with IEEE over his travel reimbursement for several IEEE conferences he organized. Both MSU and IEEE contacted the FBI, who interviewed Xi at the airport in February 2016, asking him about his activities in China and the IEEE travel reimbursement. In September 2017, Xi sued IEEE, which threatened to expel him. Xi was charged in February 2018 for defrauding MSU and IEEE $429,000 in travel reimbursement for the conferences he organized, saying his air travel receipts were fabricated, altered, or previously refunded. Xi was arrested on February 15th and spent 6 days in jail. During discovery, there were battles for documents. Xi filed for several motions to subpoena IEEE for records of his audit of Xi's travel reimbursement and to subpoena MSU for Xi's grant information. For a couple times, the motion were denied by the judge, and for another couple times, the motion were partially granted. The case went to jury trial in June 2019. In the closing documents, Xi's lawyer said that Xi did not ask for money he was not entitled to. All his travels were approved. He went to the approved places. He organized the conferences, and he did not profit in any way. He spent more money than he requested for reimbursement. The government didn't bother to look at Xi's actual travels, saying that will be incredibly hard. I don't know how to do it. Eventually, the jury deadlocked, and a mistrial was declared. From a jury note, it appeared that they could not agree on whether Xi had intent to defraud because he did not seek financial gain. Afterwards, the government dropped the case. In November 2018, the Department of Justice created the China Initiative to prioritize economic espionage cases related to China, making sure that the federal law enforcement had enough resources to pursue people with an even tangential nexus to China. The next case is Franklin Tao, professor of chemical and petroleum engineering at University of Kansas. On August 21st, 2019, the government indicted Tao for having signed a full-time employment contract with Fuzhou University, but did not disclose it to the University of Kansas. On November 17th, Tao filed a motion to dismiss the indictment, saying he never signed any contract, thus had nothing to disclose. It was a Chinese visiting scholar who was angry with Tao over authorship on the paper who made a false accusation that Tao took a full-time job in China. Then on January 15th, 2020, the government hit Tao with a superseding indictment. It did not say Tao signed a contract anymore, but charged him for failing to disclose his selection by the talents program, even though he has never accepted the offer. On June 24th, the government modified its theory again in a second superseding indictment, saying Tao entered into a contract, started his employment, and fulfilled his contractual obligations, even though Tao signed no contract. How could they say that? Because Tao traveled to China and engaged in research activities at Fuzhou University. On August 14, 2020, Tao filed a motion to dismiss the second superseding indictment, saying University of Kansas's conflict of interest form did not require disclosure of his relationship with Fuzhou University. Further, the government lied to the grand jury. For example, they knew Tao bought out teaching for spring 19, but told the grand jury that Tao's request was not successful. On September 11th, the government responded to Tao's motion, repeating the allegations that Tao obtained employment at Fuzhou University, entered into an agreement with the Chinese government, and received a handsome annual salary from Fuzhou University, knowing full well that Tao accepted no offer. On November 2nd, the judge denied Tao's motion, agreeing with the government that prospective potential conflict of interest must be reported, even if no contract was signed. This case is awaiting trial. The seventh case is Xiaoxing Xi, professor of human genetics at Emory University. Starting in August 2018, NIH sent at least 200 letters to more than 90 US institutions about individual scientists over non-disclosure of China funding. The letter for Li came in October 2018, and Emory fired Li and his wife in May 2019 for not disclosing his 1,000 talents position and funding in China. Li disputed Emery's allegations, saying he had been transparent about his China activities. After losing their job at Emory, Li and his wife had to relocate their labs to China. In November 2019, Emory asked Li to come back for a hearing about his firing, and he was arrested upon his return to the US. He was charged for not disclosing positions and incomes in China. Li had a letter of understanding with the department chair at Emory that allowed him to work part-time in China. But the criminal complaint said the letter was merely the starting point for negotiating an agreement. In May 2020, Li accepted a deal offered by the prosecutor and pleaded guilty to 1 count of false tax return. He was sentenced to no prison time, okay to travel to China, and just pay $35,000 of tax he owed to the IRS. Imagine the decision you must make. You believe you are innocent, but going to trial costs a lot of money, and there is no guarantee of a good outcome, but the possibility of long prison time. Or you can plead guilty to a minor charge and get on with your life. What do? It's a very difficult decision to make. The next case is Charles Lieber, professor of chemistry and chemical biology at Harvard University. He is obviously not a Chinese, but criminalizing academic collaborations with China is not a cover for racial profiling. Lieber was arrested on January 28, 2020, and charged for lying to DoD investigators and Harvard when they asked him about his 1,000 talents position at Wuhan University of Technology. Later, he was also charged with false tax returns and a failure to file report of FBAR. FBAR stands for Foreign Bank and Financial Accounts. People are required to report it every year if they had financial accounts in a foreign country with more than $10,000 at any time. On September 30th, Lieber filed a motion to compel productions of materials concerning DOJ's China initiative and the 1,000 Talents program. He also asked for the grand jury minutes. Normally, the grand jury transcript is provided to the defense, and it's not clear why in this case the prosecutor decided not to. On October 17th, a judge denied Lieber's motion to compel. This case is ongoing. During this time, Lieber has asking Harvard to indemnify him and advance his defense cost. To indemnify means to compensate someone for harm or loss. According to Harvard's indemnification policy, and I believe all universities have similar policies, qualified persons acting in covered roles are indemnified, which Lieber believes he is. Under the policy, the university will pay the legal fees and costs of the employee with an undertaking, meaning a promise, to pay it back if found guilty. Harvard denied Lieber's request, but said it would reconsider if Lieber provided information on criminal charges against him. Obviously, Lieber could not announce his defense strategy in the criminal case to Harvard, and his lawyer did tell Harvard that he would assert that he lacked criminal intent and had acted in good faith. Harvard affirmed its denial, and Lieber filed civil suits in October 2020. On March 21st, 2021, a judge denied Lieber's injunction to force Harvard to indemnify him. The ninth case, Zhengdong Cheng, professor of chemical engineering at Texas A&M University. Cheng was charged in August 2020 for not disclosing his extensive activities in China while receiving a NASA grant, breaking a federal law that prohibits NASA grantees from working with China in any way. He was working at Texas A&M's Qatar branch and was arrested at the airport upon returning to the US. From the transcript of a probable case and the detention hearing, we learned that Cheng talked with the FBI in a post-arrest interview, admitting that he did not disclose his China activities and mixed up his research in China with research for NASA because he didn't think NASA was serious about China collaboration. It is a bad idea to talk to the FBI without a lawyer. Anything you say can and will be used against you. Talking will not help in any way, but can hurt in big ways. The government asked the judge to keep Cheng in jail, saying he is a flight risk. The judge agreed, mainly because they have a son who is not their biological son who cannot come to the US because they submitted a fraudulent birth certificate for immigration saying he is. Cheng filed a motion in February of this year for revoking the detention order, saying he's not a flight risk. In a supplement to the motion, they presented a letter from the Committee on Human Rights of the National Academies, expressing concerns about Cheng's continued detention. Cheng has been in jail for 8 months by now, contracting COVID there. The 10th case is Gang Chen, professor of mechanical engineering at MIT. In January 2020, Chen was searched at the airport and his computer and cell phones detained because he made many trips to China. Then in January of this year, he was charged for not disclosing his many China-related activities in his DOE proposal and the progress report. The complaint said he received $29 million from China, including $19 million from Southern University of Science and Technology, but did not disclose it to DOE. The FBI, the MIT president and the many MIT faculty came out to defend Chen, saying that the $19 million from SUSTEC was for MIT, not for Chen, and the many charges are for routine academic activities. On February 4th, Chen filed a motion for sanctions of the US attorney who is charging him. It said that the US attorney's false and inflammatory statements at the press conference and in the press release misled future jurors, violating the court rules. For example, the press release and the complaint said that an email Chen sent to himself partially detailed his efforts to help China. But the government knew that the email was not Chen's own thoughts, but his notes of a speech by a Chinese official. The Chinese government responded, saying that Chen's email need not be only his own thoughts to show that Chen was interested in promoting the PRC's scientific and economic developments. And this case is ongoing. The last case is G.K. Chen, professor of electrical and computer engineering at Georgia Tech. He was arrested on March 24th, 2021, and charged for conspiracy to commit visa fraud because he hired several Chinese students and postdocs on J-1 visas, saying they would work at Georgia Tech. In fact, they work at the Chinese company ZTE's lab in New Jersey. Visa fraud is a new charge used against Chinese professors. This case is just starting. Let's summarize these 10 cases. First, Yu Dongzhu. In 2013, it was quite shocking to see that errors on the university's conflict of interest form could be a misdemeanor crime. Nowadays, many professors are charged with felony crimes for non-disclosure of China ties. Second, Yu Jieding. Although the charges seem to have no relation to China, it started as an export control case precisely because of Ding's Chinese name. Third, my case. As I said, when the government charges someone, what they say is not necessarily true. What they said in my case was totally false. Fourth, Yiheng Jiang. If somebody is upset with you and determined to bring you down, anything you have done that was questionable can bring you legal troubles. Fifth, Ning Xi. The things you may have done that was questionable can be as small as air flight receipts for travel reimbursements. Six, Franklin Tao. Don't make anyone upset with you. Otherwise, even if you only got an offer but did not decide to accept, not disclosing the offer could be charged for crimes. Seventh, Xiaoxing Xi. You think you have been transparent and told people what you are doing in China, but it may not be enough. And then you have to decide, go to trial and risk losing, or plead guilty to minor crimes. Eighth, Charles Lieber. You should be careful even when talking to people at your university. Causing the university to make false statements is still a crime. And don't expect the university to help you pay legal fees and costs just because you got in trouble for trying to bring funding and prestige to the university. Ninth, Zheng Dongchen. Don't talk to the FBI without a lawyer. It is a very bad idea. Also, never think any law and the rules are not serious. They all are. Hence, Gang Chen, don't try to be too successful and famous. If you forgot to put some of your many professional activities in the proposal forms or progress report, you may be in for big trouble. By the way, in almost all the cases, the DOJ will mention in a complaint or indictment how much federal funding you have got over the years. The more funding you have, the more serious your crime is. 11th, GK Chen. Visa fraud is a new thing. If you have J1 students from China who works at a company or national lab, make sure that your J1 request form is done correctly. Now you have seen these cases. Instead of me telling you what they mean, let's hear the perspectives of a former federal prosecutor until 2019 from the US Attorney's Office in Boston that prosecuted Charles Lieber and Gang Chen.
The great argument that the department and the federal government have made in bringing these cases is that these are about protecting American intellectual property, taxpayer-funded research. And the cases that they have brought to date do not support that theory. They are not theft of trade secrets cases. They are not espionage cases. They are really grant disclosure, failing to disclose cases. And they just have not put forth the evidence that shows that any of these researchers were involved with stealing research, stealing American IP technology, and giving it to the Chinese. This has not been an area of criminal prosecution before the China initiative. And they have essentially weaponized grant disclosure errors, which before were handled administratively by the NIH or by the federal granting agencies. They've essentially made these federal cases what they consider to be espionage or national security type cases. All of this is under the umbrella that the unsaid reason why these researchers have not done the disclosures properly is because that they are non-traditional collectors or that they are somehow spies on campus, which when you go talk to the researchers, you realize it's patently absurd. I mean, most of these researchers will tell you they're not working on classified science. They're working on fundamental research. And the point of fundamental research is that you do your research and then it is published for the whole world to see.
These prosecutions are not about protecting American intellectual property. The DOJ has weaponized grant disclosure because it thinks Chinese professors are spies for China, which they are not. Now listen to the perspectives of a former FBI agent.
When the Justice Department creates a national initiative that it calls the China Initiative, it creates a pressure on FBI field offices to work cases targeting people who they can put under the umbrella of the China Initiative. So if somebody's only connection to China is their national origin or their ancestry, that's often enough to fit under this umbrella. And my concern is that it promotes racial profiling of Asian people, particularly Chinese people. So if I'm looking skeptically at any Chinese scientist or technologist because I'm working this China initiative and I can't find that they have orders from the Chinese government to engage in some kind of misconduct or doing anything to benefit the Chinese government, but simply engaged in some kind of minor misconduct unrelated, I can still charge those cases and claim a statistical accomplishment under the China initiative. Rather than laying significant charges of economic espionage or theft of intellectual property, what we see them doing is laying very minor charges, which is both an indication that this isn't a person who properly engaged in the type of activity that justified the investigation in the first place, and seems to be part of this disruption strategy, that we can't prove that they're engaged in any kind of serious misconduct, but because of our bias that this is a problem, we can't be sure. So let's bring these minor charges just to damage them professionally. And that, of course, is not an appropriate thing for the Justice Department to be doing.
China Initiative promotes racial profiling. Criminal charges for things like non-disclosure, irregular air travel receipts, or visa requests are meant to disrupt and damage Chinese professors. Now you've got an idea what kind of risk you face just because of your Chinese ethnicity, or if you interact with Chinese colleagues in some way. Anything you do which is not perfect, or even when it is perfect, can put you in legal jeopardy. What can you do about it? First of all, you need to take it very seriously. If you are in trouble, or if you are concerned about being in trouble, treat it as the most important project you have ever done in your life. Do the literature search, study the issues, and do everything you need to succeed. Failing the project will be a terrible outcome for you and your family. If you want to learn from other federal cases, you can find all the court documents at this website, PACER, at pacer.gov. You need to register for a PACER account, and they charge 10 cents per page. But if the charge in a quarter is less than $30, it's free. You can cut your costs by using Court Listener. This website offers free PACER documents, but not all documents are available. But at least it may cut your quarterly charge to below $30, so PACER will be free. When FBI agents, investigators from the funding agencies or university council or compliance staff request an interview with you about your activities in China, find a lawyer before you talk to them. If you are searched and questioned at the airport, find a lawyer right away because you may be under investigation. Or if you are like me, arrested in a surprise raid, you will be provided with a public defender at your first court appearance. But you need to find your own lawyer afterwards. Asian American Justice Center of the organization Asian American Advancing Justice has an anti-racial profiling project that offers legal profile services. You can call them at the number given here. AAAJ also have a Know Your Rights document that informs you about your rights and tell you what to do when approached by law enforcement or when your university questions you about any connections to China. If you are charged by the government, money is a big problem. You need hundreds of thousands of dollars or more to hire lawyers and to pay expenses. Good lawyers are expensive, but losing the case is much more expensive. Actively participate in your own defense, not only because you know your case the best, but helping your lawyers understand your case quickly, save your legal fees. Most universities are not millionaires, and many people pleaded guilty because they did not have the money to fight on. I'm very encouraged by the recent successful fundraisers by several Chinese professors. Whether or not someone has done something wrong, we want to make sure that justice is done right. And the money is a big factor here. So please do help the people in need. If you need to fundraise, you can contact the organizers listed on these GoFundMe pages to learn how to do it. Being charged by the government is an extremely difficult situation. The DOJ has endless resources compared to you. It can try to keep you in jail. It can drag the cases onto where you're done. It can find something wrong you have done in your life to add to the charges. And it can offer you a plea deal that is impossible for you to decide on. The only way we can win is to prevent the government from unfairly targeting scientists of Chinese ethnicity in the first place. If you decide to speak up and fight racial profiling, visiting the APA Justice website is a good starting point. It has an exhaustive collection of news, events, community activities, congressional actions, statements, multimedia, and so on. To sum everything up, let me show you the video clip of a Senate hearing on February 13th, 2018.
Director Ray, let me ask you, what in your view could you say in this setting is the counterintelligence risk posed to U.S. national security from Chinese students, particularly those in advanced programs in the sciences and mathematics?
I think in this setting, I would just say that the use of non-traditional collectors, especially in the academic setting, whether it's professors, scientists, students, we see in almost every field office that the FBI has around the country. It's not just in major cities, it's in small ones as well. It's across basically every discipline. And I think the level of naivete on the part of the academic sector about this creates its own issues. They're exploiting the very open research and development environment that we have, which we all revere, but they're taking advantage of it.
A few days later, I gave a speech in Philadelphia. Here's what I said. I am a physics professor at Temple University. Today, I'm compelled to leave the classrooms and laboratories to join you here at the spot where our nation was born, to condemn the outrageous remarks that labeled every Chinese student's national security risk and painted all professors, scientists, and students from China as spy suspects. Just as you are, I was shocked to hear a top law enforcement official of the country put an entire group of the population under the suspicion of spying. I know from my own personal experience what this could mean. This could mean that FBI is reading all your emails and listening to all your phone calls, trying to pick bones out of an egg. 鸡蛋里面挑骨头. This could mean that someday you will get the knocks at your door by FBI agents and be snatched away. That was what happened to me. Almost 3 years ago, FBI agents knocked on my door in an early morning raid and took me away in handcuffs. The frightening scene played out right in front of my wife and daughters, who were rounded up at gunpoint by the armed agents. Based on emails I had sent from my Temple University address, the federal government charged me for passing sensitive US company technology to China. None of the charges was true. I had never shared the US company technology with anyone in China. The emails I had sent were about entirely different things. They were based on my own widely published research. When it became clear that the government had falsely charged me, it dropped the case. But our life had been wrecked professionally, emotionally, physically, and financially. Why am I telling my story? Because I want to tell every professor, scientist, and students from China that it can happen to you. You may be thinking that you came to this country just to seek a good education. My wife and I, too, came to the US about 30 years ago for better career opportunities and a better life. You may think you have integrated into the American society and call America your home. When we realized that our families was here and our careers were here, we decided to become American citizens. You may tell yourself, I don't work on sensitive technologies. To charge me, the federal government turned a commonly known device into a fictitious sensitive technology. You may say that you abide by the laws and do not violate any rules. What did I do wrong? I was just doing what the government and the university asked us to do. No matter. Now we know that our whole lot is presumed guilty until proven innocent by some in our own government. It is only a matter of time and chances that you too may get a call from the FBI. This is not right. Calling all professors, scientists, and students from China suspected spies is an affront to America's ideals. 241 years ago, our founding fathers signed the Declaration of Independence in the building behind me, proclaiming that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Persecution and the prosecution of any groups based on race, ethnicity, or national origin encroach on the very rights we cherish so much in America. So I join you today to demand that we be treated equally as any other ethnic groups in this country, no more and no less. Only when we make our voices heard loud and clear can we hope to prevent the nightmare my family and I had lived through from happening to other innocent people ever again. Thank you. And that's the end of my presentation.
Thank you, Professor Xi, for that compelling presentation, and we're all indebted to you, both in just the quality of the presentation of all the different cases, but I particularly appreciated you sharing your own story and reminding us of the human element to all this and how our lives and careers can be ruined by the China Initiative and other efforts by the US government. So thank you for that excellent presentation. We have about 30 minutes, and I would remind the audience on Zoom that you are free to type questions into the Q&A, and I will do my best to bring them into discussion and allow Professor Xi to weigh in. I also have a number of questions that I've received in advance of the webinar today. So I'm going to start with those and move quickly to the Q&A, and then hopefully we can get some of our other panelists here if they want to weigh in on some of these issues. I think that might be interesting as well. So I want to start with a question by Wang Shu from Arizona, which asks basically, how does this change how we collaborate with Chinese counterparts? And by that, I assume we mean Chinese entities in mainland China. So how does what's going on affect the nature of collaboration? Can collaboration still happen? Is there a way to collaborate with Chinese counterparts in a way that's safe and doesn't put the researcher at risk? What do you think, Professor Xi?
Today my goal is to use the actual cases to give people a sense, like what kind of risk we face. About the questions that was raised, I actually have commented more in the talks that I have given at places like Harvard and Stanford. So I gave the link on the slides, and you can go and watch those. So from all the evidences, from all the pronunciations, from some government officials and law enforcement officials, I think it's very clear. There are people who just want to stop any interactions with China, period. So how to collaborate? I think, if you collaborate, you do it at your own risks. And that's the goal that I'm trying to do today, is give you the risks of what kind of things that you do may get your trouble. And then whether you decide to do it or not, it's your choice, right? But I think it's very clear. There are people that are trying to pursue a policy that will have 100% absolute academic decoupling with China. And so, for example, there are these, in January of this year, the Trump White House issued a J-Corps report, which has recommended practices for funding agencies, universities on research security. And it has a long list of disclosure requirements. And with this many requirements of disclosing these, the message is very clear. Don't have any interactions with people in China. Like in Dang Chen's case, I mean, his activities is huge, a long list. And because he didn't include it in the current and pending support and in the bio-scratch in the DOE proposal, and did not include it in the progress report that he makes for his grant, then he's charged for that, for non-disclosure, for a false statement. So, if you ask me, there are risks to collaborate with anybody in China. So you have to weigh risk and reward and decide whether you want to do it or not.
If I can co-opt moderator privilege and also just quickly chime in on that question. I think in my own experience, and again, I'm a political scientist, and so it's a much smaller research enterprise. But my own practice and my own rule of thumb is to never, ever accept a single penny from a Chinese entity. And I've done that my entire career, including graduate school. No funding, no.
It doesn't matter. It doesn't matter.
No, but I'm just saying, I think that's one possible practice.
So the new rule is very clear. Paid or not paid, it doesn't matter. You have to disclose.
Okay, sure. But I'm just offering my own experience, my own thoughts. Another thing I think should be discussed and considered is participation in talent programs. It seems a lot of the cases that are initiated have some link to talent programs. And we know that many members of the intelligence community in the US government view the talent programs as problematic. And so I think folks that are participating in those programs, that's something to consider very carefully, given their status in US political discourse. But Professor Xi, I'm happy to hear your thoughts on that as well.
You mean the talent program?
Yeah.
First of all, the freedom of movement is a fundamental human right. And many government run government-funded talent recruitment programs. And in previous talk I have given, the Jason report, for example, listed many of the government-funded talent programs from many countries. Right? So I think whether a person participate in any talent program, maybe a Hamburg fellowship or Roosevelt programs in the UK, or one of any numbers of government-funded talent recruitment program, as long as the person does not violate any rules and follow the laws, and I think they have all their rights to do it.
Okay, thank you. So I wanted to move on to additional questions from Carl Patton and Yang Yuhong. Carl at Colorado State and Yang from Minnesota, both asking questions of a similar spirit, which is what can be done to affect U.S. policy in this area, if anything? In particular, is there a world in which the China initiative is rolled back, and what efforts can be taken to spur that type of change?
I think this is summarized. The answer is in the very last paragraphs of my speech that I recited. That the only way we can impact the policy is for all of us to speak up, because the policies that is being pursued, cracking down on the Chinese scientists and the people who collaborate with colleagues in China, I mean, these are number one, not fair. It's racial profiling, and we don't see that people who did not include, let's say, Holmberg Fellowship in their progress report will get charged for felony crimes. Right? And this is obviously targeting scientists of Chinese ethnicity, and so it's not fair. And also, it's a bad policy for America, because these policies aim to shut down any academic collaborations with China, and this will be impact to international collaborations with anybody, and that is bad for fundamental research. And so what we need to do is to tell people about these facts. Right? I showed these poll at the beginning that 55% of Americans support limiting Chinese students studying in the United States. Right? So why is that? Because they have heard officials talking about Chinese students steal secrets back to China. Right? They heard these kind of things again and again and again. And so it's up to us to tell everyone that that's not true. And for example, students are paid by the universities here for TA or RA. They're not paid by the Chinese government, and the majority of them stay here. And actually, they create all these discoveries and inventions here in the United States. So there are laws. There are bills that are introduced that will completely ban students' visas for STEM students from China. And so if that becomes law, it will be, terrible for this country. And so the only way that we can help prevent this from happening is speak up. Talk to your university administrators, telling them that the J-Core cannot be allowed to be implemented as it is now, because it's bad for science and technology of this country, and it's a discriminative against scientists of Chinese ethnicity. Tell your friends, tell your family, talk to your representatives, and tell everyone about the fact. And today I didn't really talk about how false a lot of statements made by some officials are. But you can watch my talks at Harvard or Stanford, where I went through a list of falsehoods that we hear again and again. Right? So tell the public, tell everybody that we know about these facts, so that we can, only when the public, American public, understand what the fact is and how bad the current policy is to our own research enterprise, then we can hope to have some change in the policies. And so that's the only hope that I can see.
Professor Suo, I see your hand is raised. Would you like to weigh in?
Thank you both for this great opportunity, Xiaoxing. Thank you so much for speak out and also clear presentation of these cases. Now, so I only studied one case, Gang Chen's case, because he's a friend, and I just couldn't believe, based on 20 years of knowledge of him, he would be a criminal. So I studied the presentation. Of course, it's full of falsehood, just rubbish, a part of shit, really. So given that, so this is give me an idea. So the government can put out rubbish without accountability. You must give a lot of thought of this, because in your case, FBI wrongly accused you and dropped the case without apology. So no accountability. So from your perspective, what can we do as ordinary citizens just to make this country a better country? Regardless of China, this has nothing to do with China, fundamentally has nothing to do with China, right? You just falsely accuse your own citizen. This is wrong. We all know this is wrong. This is wrong because the government can do this without accountability. That's wrong.
You know, that's why I played the audios of these two former law enforcement officials, right? One FBI agent and one federal prosecutors. And they have stated very clearly that, as you said, this has nothing to do with protecting American intellectual property. This is just to damage and disrupt Chinese professors and you know, scientists. And so you know, once you are charged, it's extremely difficult. It's extremely difficult. The pressure you're under, and emotionally, financially, you know, physically. I mean, it's just, if you haven't gone through that, you will not be able to understand. And so, you know, I have gone through that. I can imagine in my mind what Gang Chen went through, what every one of these people went through. And you know, I told you a little bit about my details. Of course, every situation will be different, but pretty much they probably will go through similar things, right? And indeed, it's very hard. And as I said, everything you have done in your life is under the microscope. And they can, if they find anything, they can add it to the charges against you. So let's say you say, okay, what I'm doing is academic research and so on and so forth. Have you filed F-bar? If you have not, you violated the law, right? So it doesn't really matter however many people come out to defend him. Have you filed F-bar? So it's very difficult. The only way we can win is to prevent the government from unfairly charging these scientists of Chinese ethnicity in the first place, right? So, you know, we don't see, as I said, that people got charged for false statement for not putting their, let's say, their Humboldt Fellowship, their Max Planck Fellowship in their progress report, right? We don't find them to be charged for failing to file F-bar, right? So if you filed, you know, tax return incorrectly, you have a chance to amend it, right? And or you can be fined, and so on and so forth. You don't see people being thrown into the jail for doing that, right? And so the problem is the policy, right? As the former FBI agent said, there's this China initiative, right? So as an FBI agent, you want to have statistic achievements. and statistical achievements, and you want to bring cases. And then even if, you know, as he pointed out, when you have minor violations, they can still charge you and count it under the China initiative. So the only way is for all of us to speak up and talk to our representatives, talk to our university administrators, and try to put a change to the policies.
Thank you. I wanted to allow Professor Kai Li to weigh in or ask a question. Professor Li, please.
Thank you. First of all, thank you and Xiaoxing for giving such a wonderful webinar. I am actually asking a question on behalf of someone who posed a question, and this person asked what to do. He or she heard that some number of senators recently wrote a letter to against the rumored DOJ's amnesty program, which is I think there was an article on New York Times about whether previously not disclosed in collaborations and such with China will be ignored. And there's established a timeline from this point on. People all follow the fully disclosure program. I think the question is about what suggestion you would have.
So I do not agree with the amnesty because it suggests that these people have done something wrong. They have broke law or something. And in the talk that I gave, I also mentioned in this talk about the Jason report. Right? Jason is an elite group of scientists who have all the clearances and access to all the classified information, and they recommended that non-disclosure should be dealt with by the funding agencies and the universities, just like scientific misconduct. So when you have scientific misconduct case, the really bad ones which violated laws, then the funding agency refer that to FBI. It should not be treated as crime at the beginning, right? And so many of the cases should be treated as the research integrity case, should not be treated criminally. And treating these kind of cases criminally also are against DOJ's own rule, because DOJ's own rule says that if there is appropriate non-criminal alternatives, then that's the ground for declining prosecution. And so these kind of cases, like a non-disclosure, there is non-criminal alternative, as suggested by the Jason report. So, I have discussed at length about these issues in the talks I gave at the Harvard and Stanford and other places. And so from that standpoint, I do not agree with this amnesty program in the first place. But I read the letter that the people referred to. And in the letter, it was saying that all these people at universities are trying to steal secrets for China. And so all these premise is not true, right? As I talked about in my talks, and we professors do fundamental research. We don't do sensitive research. We don't do classified research. What we do, we publish it. Actually, the former prosecutor mentioned that in his webinar too, because what we do, our fundamental research, basic research, we publish that. In my talk, I showed a video of the NIH director. He said very clearly, what we do in science, we publish it. You don't have to steal it. So all this premise of all these Chinese professors steal secrets for China is false, right? So, all these arguments that the letter was based on were false. And so that's my take about
Professor Xi, do you feel that given that there's such a misunderstanding in that letter, do you feel or do you suggest people should reach their senator if their senators happen to be in the region to educate them?
Yes, but senators or representatives, they listen to their voters. So talk to your representative, talk to your senator, and tell them about the fact. Again, if you have not heard my talk, you can, I gave the link on my slides. Go to those talks where I laid out why what they were saying are false, right? So we need to tell the public these truths, these facts. We need to tell our representatives these facts so that they understand the policies that, like China Initiative, that's not only unfair, but it's bad for America.
We are running a little short on time, and we have an abundance of great questions. I wanted to allow Professors Zhu and He also the opportunity to ask a question or weigh in. So Professor Zhu, it's please.
Thank you, Xiaoxing, and thank you for using your own experience. Say how that the scaffold that the DOJ's China initiative placed on every Chinese American scientist here. And my question to you is relevant to that. What is the future? What is the right policy the U.S. government should do? The motivation for that the China initiative is try to target China, to stop China's advance in science and technology and maintain the U.S. leadership in science, to block the communication, any communication from U.S. scientists with China. That's the motivation. However, that by creating the fears, by doing this racial profiling is counterproductive to that the motivation about U.S. the technology leadership. And there many of us come to this country is to pursue, as you said, to pursue our own dream. And we contribute to this country significantly in science technology. And open science research and communication are really that the key to maintain the U.S. leadership in basic research and innovations. So if you try to tell that the DOJ or tell the U.S. government, what is that the right policy that the government has to make in order to promote that this basic research and communication at the same time that the create maintain the U.S. leadership over Chinese competition in science and technology?
You're right. We are not denying that there is a problem of China influence, right? And at the very back of my talk, I gave the link to an article that I wrote that was published on Nature Reviews Physics, and I talked about how the United States should deal with this issue and protect its own science and research. And that is, there is a blueprint, there is a roadmap about how to deal with this problem. That is the Jason report. Right? The Jason report had access to all the unclassified and the classified intelligence information. They reviewed them all, and they concluded that these bad things that China has done to influence American research happened. But how frequently they happen, it's not clear, right? And in the areas of fundamental research, it's not clear at all. I mean, fundamental research is open. They don't have to steal. They can sit on their sofa and read the literature, right? What we do, everything we do, we publish it, or maybe we file a patent. When you publish a paper, you are required to put everything in there so that anybody who read it can reproduce it. When you file a patent, it has to be such that people who have some knowledge about the general knowledge about the field can reproduce it. Right? So it's all out there. You don't have to steal it. Right? So the Jason report analyzed what China has done to influence American research and made 9 recommendations, and including how to deal with a failure to disclose conflict of interest and conflict of commitment. And basically, you know, I think the U.S. government should establish its policy towards China in terms of a scientific interaction based on the Jason report. Right.
Thank you.
Professor He.
Yeah, thank you, Professor Xi, for this really nice lecture. I think the core message here is about open science. And I feel like some politicians forget that US benefited tremendously from open science. Going back a century ago, where did the US science come from? It was built from all the knowledge generated in Europe, right? And this country had lots of professors, eminent scholars coming from Europe to build the foundations of science in this country. So US benefited tremendously from that open science spirit. And I feel like that's something we need to change, really embrace and communicate with politicians and the community that open science is good for this country and the entire human being.
I agree 100%.
No, and I would just say from my own vantage point, you know, if you read statements by politicians or even journalistic coverage of the China initiative, there's a tendency to latch on to the sort of handful of espionage cases or sort of make a lot about some of these instances. And there's almost no effort to think about the benefits of collaboration and the benefits of the Chinese American scientific community. And even if there were cases of espionage, just the overwhelming evidence that it's a net gain for the United States, and it's not even close. But there's a complete blind spot for people who are arguing about kind of greater measures of security in this area. So I think, and it's sad to have to say this, but I think one thing that this community could maybe do collectively is greater efforts to promote the contributions of the Chinese American scientific community and make it clear to the U.S. policy community that the U.S. has benefited tremendously from the flow of talent from China to the U.S. or from the Chinese American community. I think I have time for...
Rory, can I add something?
Please, yeah.
So since the China Initiative was established, there have been 13 professors, university professors charged. 0 case is about theft of intellectual property. And they're all about non-disclosure. One of them is about the J1 visa, right? All of the others are about non-disclosure. And as the former prosecutor said that I showed in my talk, they simply have not shown any evidence that any of these people have stolen intellectual property for China. They may have not filed their taxes correctly, they may not have disclosed their China activities properly, or they may have done something, but none of them has stolen any secret for China. So the China initiative against all these university professors simply has not shown any evidence that any of these people have stolen American secret for China.
And I think actually that's a great place to end. We are officially out of time. I do apologize. There were some excellent questions that we weren't able to get to. And in particular, I think there's a lot of comments on legal strategies and legal resources available to the Chinese American community in confronting this issue. And in particular, the question about a potential lawsuit or collective action lawsuit is an interesting one. So perhaps we would encourage future seminars on this topic, because I think it's one that we didn't quite get to today. So I think we will close there. Please join me in thanking again Professor Xi for all of his work on this issue and for sharing this compelling presentation today.
Thank you for the opportunity to speak here today.
Xiaoxing, thank you very much.
And thank you, everyone. Thank you, Rory, for moderating an excellent webinar. And a last announcement to the audience, if you are still here, please stay tuned for our Chinese American Scholar Forum's monthly webinar series. And our next webinar will be about a JSON report that Professor Xi and several panelists have mentioned in today's webinar. And the speaker will be someone who contributed in writing the JSON report. So please stay tuned about next month's webinar. Yeah, that's conclude today's webinar. Thank you very much. Have a great night.
Good night.
Good night.